Good afternoon. I'm Michael Corey, the attorney for the defendant, appellant Timothy Patrick March. The Supreme Court had requested that two specific issues be briefed regarding, as part of the supplemental brief, and I'll go over those issues with you. The removal of fixtures by a mortgagor after the sheriff's sale but before redemption period. Facts in this case, as the court's aware of, involve fixtures being removed during the redemption period. The question is that unlawful under the larceny statute, the section of the Michigan Penal Code? There are two areas that were exhaustively and intensively argued by the prosecution, both the trial court level and the Court of Appeals. That was a civil statute in the Revised Judiciary Act 63278, and it was cited in the Court of Appeals opinion as supposed grounds for their opinion that my client had a duty not to remove fixtures during the redemption period. Well, as it turns out, the Michigan legislature had, in fact, itemized what is damage. In other words, that statute says you can't damage a property during the redemption period, or also civil liability attached to the owner if the owner does so intentionally. However, the Michigan legislature held or ruled later in January 2014 that particular section only applies to fixtures effective 2014. The crime alleged here took place, or the alleged occurred in February of 2013. So it's clear the legislature did see fixtures as a form of damage under the Revised Judiciary Act at the time this incident occurred. It wasn't until afterwards. So that was a key point. It's been a supplemental authority as that because it became apparent in the Michigan Bar Journal article that cited the timeline and how the evolution of the.
Do you believe the fact that there's no civil penalty has something to do with whether there can be a criminal penalty?
No, I don't. I believe they're two separate things.
Okay.
If you look at the statute, it deals with owners intentionally damaging property.
Right.
And in this case, my client's not an owner; he's an agent of an owner, and we believe it's not relevant to the criminal statute.
Can I just get a big sense of what your argument is? Is it your argument that as the legal owner during redemption, the legal owner can lay waste in any way he chooses to the property, even if he has no intention of redeeming, and he's not, because he's the legal owner, subject to any criminal penalties for doing so?
I'm not saying laying waste. I'm saying.
Well, I mean, destroying, removing fixtures, taking the furnace out, making the place uninhabitable.
I'm not saying anybody should damage any property whatsoever. Intentionally damage. That's what that statute, civil statute, is.
No. Look, let's put this. You say it isn't even applicable. All right, let's leave that. Okay. We're talking now about whether there is any criminal basis.
Any or larceny? I thought we were
I'm starting broadly.
Oh.
Broadly, is it your position that as legal owner you can just do whatever you want during the period of redemption because you are the legal owner?
As a matter of criminal law, I believe a person can remove fixtures. I don't believe it's an issue before the court as to some.
Can or can't?
Oh, they can remove fixtures. Yes, I believe it's under the larceny statute. It doesn't cover all fixtures.
No, I'm really trying to get first the generic understanding of what the scope of autonomy is of a legal owner during a redemption period, where if they don't redeem, the entirety of the estate reverts to somebody else, the equitable owner, the purchaser at the sheriff's sale. That's the context, okay? What I'm asking is it your position that as legal owner, you can essentially do anything you want without being subject to criminal liability for it because you're the legal owner?
I can only speak as a larceny statute. I could speak to that. I haven't researched malicious destruction of property. They brought it up as something else, but I believe under the. I believe they can take any fixture they want to out of the house. That's what I believe. I don't.
Is it embezzlement? If you know that if you detach fixtures and you sell them, that they will not be available to the equitable owner, is that embezzlement?
No, it isn't.
Why?
It wouldn't be because during the period somebody has property like that, I don't believe the larceny statute covers that.
And then I'm trying to figure out whether there's something else going on. I'm trying to figure out what the scope of the rights of the legal owner are. Because under normal contemplation, fixtures are a part of the realty. And once you sever them, they become personally, but the act of severing them can have legal consequences. If you don't have the right to sever them, there may be both civil and legal consequences.
I believe there is a right to sever them, yes. As the fixtures, I believe, yes, there is a right to sever those anytime before the redemption period runs. They can remove those. Just like any time, if I purchase a home for $100,000 and I remove a chandelier and sell it, I don't have to get the mortgage company's approval on that. I can do it. And afterwards, if the redemption, before the redemption runs, if I want to remove fixtures, yes. A light bulb, yes. I believe that that's perfectly legal. The fixtures.
And things like ductwork and the furnace?
I believe that anything that's a fixture can be removed.
So during foreclosure, the legal owner, the homeowner can make the house uninhabitable.
I would say it's uninhabitable. I would say.
Well, furnace makes it in Michigan uninhabitable.
Well, I would say at any type of fixture, because during the period the house is constructed, the period that the house had, and I believe that those fixtures can be removed. I don't believe that changes after the sheriff's sale. I believe it's a fixture, it can be removed. I do believe that, yes.
Counsel, do you feel that civil penalties are sufficient in these circumstances?
Well, I don't believe, I think the current, under the civil penalties, like I said, they could actually bring an action for waste. They could try to do that. They could try to do that and argue in court. I would dispute that, but if they have an action for waste, that's a civil damage. My view is that the Revised Euclid Act, Section 3278, didn't include fixtures until after as covering that statute, until after my client left. So I don't believe there is any civil remedy either, but I mean, arguably they could try to bring an action for waste.
And then, counsel, who do you believe during the redemption period, who do you believe is the actual owner of the property?
The legal owner would be the homeowner, the person having it, the person who was foreclosed upon. During that period, a legal title and legal possession resides with the homeowner.
And then what rights do you feel that the purchaser at the sheriff's sale, before the redemption period has concluded, what rights do you feel that person or individual has to the property?
That person has, I think it's a structure. I believe that the basic structure itself is going to be violated. Don't forget, when a person buys this at these execution sales, they get it at bottom dollar because they don't know what's in there. They could be buying into a termite-infested home. They could be buying into all kinds of damage. They don't know. The person would not know until after they buy it. So if there is no furnace in it, a lot of people in Detroit don't even have furnaces. They have space heaters. So, I mean, to the extent that there's a situation here where there's ownership and possession, that's what the trial court hung their hat on dismissing the case. They freely prosecuted. We have possession here. The person has possession who's alleged to be stolen. So that's end of case. They could see that in the record. So I would believe this. I believe if somebody took off a roof, that would be violating the rights of the person who was the.
Why would that be?
Why?
Pardon me?
Why would that be?
Because that's a structural thing.
Well, wait a minute. So is a fixture.
Fixture is not structural.
Wait a minute. A fixture, while attached, is considered part of the realty. Is that? You didn't go to that class in property?
No, but it's a fixture. It's part of the realty, but it's not structural. I'd make a line structure.
So the difference is not what is part of the realty, but what can be detached from it.
Exactly. What can be detached?
Well, what about shingles?
Well, shingles are not. I'm talking about the structure itself. I'm talking about the basic structure.
Yeah, well, she's saying, well, now shingles aren't part of the structure.
Well, that's not part. I wouldn't consider a fixture. It's permanently attached there. That's part of the structure.
You could take the shingles.
But you can't commit arson.
I would say you can't
burn
destroy a
them.
structure. If they start moving, structure of the house, concrete there, tearing up the concrete, tearing up the house entirely, the structure of the house, I would say that may violate the rights of the person at the execution sale.
Well, doesn't the statute itself give the purchaser all of the estate at the time of the purchase? Doesn't it say that?
What they do have is this. What they have, according to the law, there is an
All
equitable
the
interest.
right, title, and interest which the mortgagor had at the time of the execution of the mortgage or any time thereafter. Doesn't that describe the rights of the purchaser to the estate at the time of the sale?
I don't believe that's correct. I don't believe that's.
You don't believe I read it correctly?
No, I believe that if that's cited in the sheriff's deed, it's not totally correct. I think the law says that possession and legal ownership resides with the purchaser, or resides with the, not the purchaser.
What does that mean? Just putting that aside.
With the homeowner.
Yeah. Let me ask you a question. If during the redemption period, a random third person, let's just call him Chief Justice Bob Young, went into the home and stole the fixtures, who would be the victim of that crime?
If a random person came in the house?
Not that random. We know his name.
Okay. So if somebody came in the house from outside and
Stole the fixtures. Who would be?
Shady Bob
And they want to
fixtures dealer.
charge. They want to charge Bob Young. The fixtures are all in his house. He's collected them. Who's the
I
victim?
like furnaces.
Who's the complaining witness?
the complaining witness is the homeowner.
So it's your client,
Yes.
not the purchaser.
Not the purchaser, no.
Not both?
I would say it's my client. I couldn't say, I don't believe it would be I mean, that'd be an issue of discretion of process, how to structure that, but I think my client would be.
It doesn't really matter for purposes of the prosecution, right? Because
Right.
the complaining witness, it doesn't really matter. It's going to be the people versus Bob Young, right? So the action's going to be brought on the,
Right, exactly.
Right.
Exactly. And obviously getting,
But she's trying to
I want to
figure
know
out
who do they call to testify to say he did not have the right to steal my fixtures? Bob Young, stop it. Don't steal my fixtures. You didn't have the right to steal them. Is it
They
your
were
client
pretty.
or is it the purchaser? Somebody has to say that on
Yeah,
the witness stand. I can ask Mr. McCready when he gets up. Or
yeah, I think, and maybe if it was a structural issue, I don't know, maybe a
What we're
structural
trying to
issue.
figure out is what the
it means.
the
Who has
relationship
what?
between, we have an equitable owner and a legal owner.
Yes.
The equitable owner seems to have some residual rights that the statute creates if the redemption doesn't occur. And essentially what I think your argument is, until the redemption period is over, I can just do whatever I doggone well as long as I don't cut holes in the roof.
No, I believe that, I believe this. I believe that
Not
the
legal,
fixtures,
not
no, that the fixtures themselves are the property of the person having it, that's their possession.
Possession.
Okay, and my view is that, in fact, the entire possession still resides. Isn't a larceny case. I mean, it's, the case is relied upon by the Court of Appeals and the prosecution were cases where the possession went over to the,
Could I, okay, let me just ask a related question.
Yeah.
I know you're charged with larceny here, but if that goes away, your clients might be charged with something else. So I want to ask you the question, do you know what embezzlement is?
I have an idea, yes.
That means you actually have possession,
Yes.
but the owner of the property has constructive possession so that you cannot alienate that which is entrusted to you and convert it to your own use. Would this constitute, since the equitable owner, at least theoretically under the statute in some of our cases, seems to have a statutory expectancy to the property at the time of the sale, would a legal owner who starts severing fixtures be liable to an embezzlement charge?
I would argue no, because there's no case that says that whatsoever. The only case that I cited was a Texas case where beams were taken out of a barn by a person who was held a leasehold. They were a tenant. And the court said, whatever this is, it isn't larceny. It isn't larceny. I don't believe it's embezzlement. I haven't looked at it. It's not an issue in this case, but I would say no, embezzlement involves agents and all the rest of the 9 yards.
It involves what?
Agents and that type of thing.
Well, won't we know
Employees.
the answer to the embezzlement question in the near future? Because the prosecutor's indicated that if he loses this appeal, he's going to bring embezzlement charges against your client, right?
Whether he's going to do that remains to be seen. I don't know. That's what
Of
they've
course, it
indicated.
remains to be
However,
seen, but that's a question that we may have a chance to opine on in the not-too-distant future, right?
okay, that wasn't actually part of the lower court proceedings. It wasn't brief, but I would say no. I would say this is not, embezzlement is not part of this case, I don't believe that the case law would cover embezzlement. So they haven't cited anything that says that it covers it. I see no case law whatsoever.
Thank you.
Let me just ask one more thing, please. Isn't the significant thing in larceny that we kind of compare the equities in a sense? In other words, the relationship between the possessor of the home in this case, that is the defendant, and the mortgager involves a different kind of balance than would be involved in comparing the legal rights and the ability to commit larceny when we're comparing what a third party does vis-a-vis the homeowner. Isn't that really the critical aspect of the common law of larceny, that we look at the respective equities of the possessor and the non-possessor, and it's a different kind of relationship than when you're comparing the possessor and somebody who's an entirely third party who has no right of any sort to anything within the home.
I would say this, I would say the larceny statute does cover that, and I say it in my brief. The fact that the only mention of fixtures in that larceny
I'm
section.
not just talking about fixtures, I'm talking all across the board in terms of the larceny offense. We look at respective equities and who has the primary right of possession, because at common law, we know that the law of larceny was focused upon trying to maintain tranquility and placidity in society. And so even persons who may have had some ownership rights could be convicted of larceny under circumstances when they were invading the rights of individuals who had some possessor rights to that property.
I would agree. That's what Sheldon says, and this differs from Sheldon's because there was no possessory rights at all in this case as to the execution sale purchaser.
I was trying to be
None.
helpful, but
Very good. Nice try there. Thank you very much.
Okay.
Good afternoon. May it please the court, Dave McCready and Madonna Blanchard on behalf of the people. I think the court has hit on one of the key issues here, which is that if the defendant is right, then it would not be a crime for him to have put this entire house on a trailer and carted it away. If what the defendant did is not a crime, then it wouldn't be a crime for a lessee to take all of these same furnishings out of an apartment while they had legal possession of the apartment. But that simply can't be. The fixtures are part of the realty, and the sheriff's sale purchaser has a legal vested interest in that realty, which then, when the fixtures were severed, became real property subject to being stolen, either via larceny or embezzlement. And I would invite any questions at any time.
I don't understand your lessee analogy. A lessee doesn't have any ownership or,
Right of occupancy.
yeah, that doesn't seem.
It's a lesser right, for sure, but
Way lesser,
Than
like
a
not an
legal
owner,
right. Yeah.
like different, yeah.
he has legitimate possessory rights.
Possessory, right. But a legal owner has a right to do things like deface the property by applying his own color scheme to it. However ugly, orange. They have a right to do things like that. Might lower the property value, but they have a right to do it. So I don't understand the lease.
That may be, a little bit far afield, but the initial
think it
point
is.
remains that if he's right, then he could have carted away the entire house. There is no distinction.
But counsel, who's the owner?
Well, the Gordian knot here unravels if you look at this as sticks in a bundle, like almost every other Supreme Court has, like the United States Supreme Court has. And the possessor has the stick that says, I have the current right to possess this, but he does not have the stick that allows him to dispose of it.
But who's the owner?
Well, he owns some of the sticks, and the sheriff's sale purchaser owns others. There is not one single owner in this circumstance.
Or do they just have a contingent right to all his sticks at the end of the redemption period?
I agree that the right is a future interest. It's a contingent right, but that makes it no less a vested.
It's a current equitable right, but it's the maturing of the right into full ownership is contingent, right?
Correct. It's contingent on whether the possessor redeems.
Yes.
But isn't
Right.
that, you mentioned the stick about disposal, and I think all would agree that the legal owner, so to speak, after the sale, can't then sell the property to somebody else. So in that sense, I've been sort of thinking about the case the way you just mentioned, which is they're more like a tenant in some ways at that point. They have lawful possession of the property, but they can't do everything that every other owner of property can do, right?
Correct. They cannot dispose of it by selling it, they can't dispose of it by giving it away, they can't dispose of it by destroying it.
Okay, but let's take this hypothetical. So let's say that I lose my home in foreclosure, it's sold at a sheriff's sale. During the redemption period, my rich uncle Bob comes to me and says, I'm
Give me
going
your
to...
fixtures.
He says, look, I'm going to give you some money. I'm going to give you some money to redeem and fix it up. And we're going to flip this house. So take out all the cabinets, take out all the countertops. We're putting in granite. It's going to be really high-end. I take all the stuff out. I do all that, put it in my friend's garage. And then my rich uncle Bob says, sorry, changed my mind. Larceny? So now I can't redeem because Bob didn't come through and I took the stuff out.
So there's two things I would say to that. One is there's got to be a felonious intent. And from your hypothetical, I see no felonious intent. Here, he took the stuff out, and when the police came to get it, he said, that's not the stuff. I've got this off Craigslist.
Well, he had no intent of redeeming.
Well, correct.
Okay, so everything he was doing was not in furtherance of perfecting or re-perfecting his legal ownership. It was something else.
Right. But in Justice Larson's hypothetical, I don't see a felonious intent. But second of all,
But
let's say
that's
that...
the only issue is intent.
No, then there's a second issue is this. If the redemption period expires and you still have my cupboards and my countertops in your garage and you don't put them back, then I think you can infer there's a felonious intent, right? In other words, maybe during the redemption period there's a gray area, but once that redemption period expires, time is up. It would be as though I shot somebody and they didn't die for a year, right? You can still charge the murder when that year is up and the person dies. So as of here, the question is, when did the larceny occur? Well, we know at the very latest it occurred when the redemption period expired.
If I commit larceny, don't I have to commit larceny very clearly against a specific person?
Well, you could commit it against multiple people. You could commit it against both the possessor and the equitable title holder. Because, as I mentioned, they both have rights in this property, and you've infringed on both of their rights if you come in as a third party and steal that.
No, we're not talking about third party.
We're talking about
I'm
the
the guy who
legal owner.
owns the house.
Okay, yes, then you have infringed on his future possessory right to that house. When he takes the house when he bought it, it had all these fixtures. When he comes to take possession of it, it doesn't.
But he didn't know that. When he went to purchase it at the sheriff's sale, he doesn't know what's in the house because you don't get a right to inspect.
Well, you didn't at the time. Now you do. But
Okay, but at the time, he
in
didn't get a
fact,
right
he
to
did.
inspect.
In fact, he did. In fact, he went there the day, maybe the day or shortly thereafter, and took pictures. So he knew what was in it when he bought it.
Does that matter? So like if there had been another person who hadn't had the opportunity to inspect? I mean, are we saying criminal liability is going to turn on whether or not the purchaser had a reasonable expectation that these things would be in the house?
No, on whether they actually were in the house. So this is why we don't have a lot of these cases, because it's unusual for the sheriff's sale purchaser, at least
To
from
know
what I understand.
that he's been robbed.
Right, to know that they've been robbed. I agree. But that doesn't make it any less of a robbery that I can prove my case here.
If we're really drilling down on this case, and there's a couple different issues, but assume for the moment that I agree with your position that fixtures could be the subject of a larceny once they've been severed, and that both sides have sufficient possessory rights in the property for there to be a larceny.
Possessory?
You don't have possession.
No, the equitable owner does not
I'm
have
thinking
possession.
of it as you mentioned, it's a
Contingent
contingent
future.
future possessory right. And this would be a crime against that right if you disposed of the property. So in that sense, I look at them as both having some form of possessory rights, one current possession, one future contingent possession. The point I'm trying to get at, and the fatal defect I see in the larceny charge here, and I'd like you to address, is the notion that larceny is a crime against possession. And according to all the commentators, it has to end somebody's possession, and there has to be a transfer of possession where you're taking it from somebody else. And that we don't have here, and that makes me think this may be, as the Chief Justice has suggested, something more like and embezzlement, and I'd like you to address that.
So generally speaking, you're correct, but there are many, many exceptions. I've mentioned these in my brief. The paradigm is when an employee has the charge of a cash register. They have possession of it, but if they take that money out, it's still larceny. So it's not a requirement. I mean, generally speaking, it is.
Possession of the cash register.
They don't have possession of the cash.
Control.
They have control, but they don't necessarily have possession.
Well, what I'm saying is that no one took it, that it was not taken from the employer exactly. It was taken, they are the ones that have control over it at that time, and they take it. The other case was
I mean, that would be their agent at that point.
the general point is that it does not need to be taken from the victim.
But it was, in some sense, what we're talking about is a contingent right of complete ownership, which is severed by the removal of the fixtures. You said this at least becomes a larceny at the point when the redemption period is over and the purchaser's contingent right of possession matures, and then they are entitled to everything that was in that house at the time of the sale.
Correct. Everything that was
So
part
you're
of the
saying
house.
that we could have a delayed larceny here, that at the time they were
Future
taken?
contingent larceny.
A future
Right.
contingent.
Yeah.
That at the time they're severed, I have a right to sever them arguably as owner, but if I continue to possess them after I've lost the right to own them, I've now committed a larceny. How does that work?
Well, so I have to prove a felonious intent. I can certainly prove it at the end of the redemption period, but I think what Justice Viviano is getting is at the point that these are severed, can I prove the felonious intent?
Right.
And can I show this taking, this trespass? But the law says that trespass can be constructive. So a couple things I would say. One is that here's an example. There's a case this court decided, People v. Harmon, it's 217 Mich. 11, it's a 1921 case, and the court said that even lost property can be the subject of larceny. Right? The point is that it doesn't, that taking, that trespass is not a necessary element. Generally, courts talk about it in those terms, but it does not need to be actually taken from the possession of the victim. So now, the court could say, here's another exception, or it could say this is not an exception, in which case it's an embezzlement. I mean, on that issue, it's an either-or. It's either larceny, because you don't need, excuse me, because you don't need the trespass, or if you do need the trespass, that it's an embezzlement. Either he had no right to sever those, and in doing so, it was a taking from the constructive possession of the sheriff's sale purchaser, or he did have the right to sever those, but he then embezzled them when he didn't transfer them over at the time of the equity.
Right, because that
redemption.
gets to the right to sever. That goes to my, flipping the house.
Right.
So-
So I do agree that he probably did have the right to replace those cabinets, to sever them and upgrade. At the end of the day, if there is, I mean, the law here is pretty clear that if he has a real good faith, a bona fide good faith belief that what he is doing is allowable, then there is no felonious intent, and I can't win. So you can upgrade.
You opened up by saying if the appellant is correct, entire houses can be gutted and nothing can be done about it. Well, let's look at it if you're correct. How little can be taken before you're charged with a larceny? So, for example, if this defendant gave his parents a very beautiful light fixture that was hanging in the bedroom 20 years ago, it's been there, it's worth a couple $1,000s, and he says, this is sentimental to me. I'm going to take it down, and puts up the $9.95 Walmart fixture in its place. Is he subject to a larceny?
Yes, but I would say that the law is also clear. There are cases on point that say the contract can override the statute. In other words, if you want to put up this beautiful fixture, then you need to tell the mortgage company, this is what I'm doing. I'm replacing the old one. And you have to have an agreement with the mortgage company, because
But that's about who can recover what in some civil dispute.
is
Justice
crime.
Zara's question is, if you're right that you can charge a crime under these facts, why couldn't you under those
you
facts?
can. This is what I'm saying, is that anything that becomes a fixture becomes subject to the sheriff's sale. And so if at the sheriff's sale, it's sold with that fixture is part of the house, and it just got bought at the sheriff's sale, and if you take it, you've stolen it.
Mr.
So-
McCarty, can I go back to I actually, I feel like the purchaser has some rights to the property. I'm not troubled by your trespass, no trespass. I actually think he has some rights to it, like you don't want, but I also think the mortgager obviously still has some rights to it. At least that's what our court has said. I just read the law and try to apply it, and we've said still has ownership and possessory interest. So going back to my question about when Bob Young, a third party, goes in, who do you put in the complaint as the complaining witness? Is it the mortgager or is it the purchaser?
Well, I would say it would be both, or
Would you-
either one.
Either
because-
one is fine?
Right, because he certainly has violated the possessory interest of the possessor, the person who lost it at sheriff's sale but still has the right of redemption. But he's also taken the right of the equity holder.
Okay, and so if the mortgager did what he did here and went in and took the, if you're right, if it's both, then either can be a victim and either could steal from each other, I think, during this period. So if the mortgager goes in and steals the fixtures, but puts them back, I don't know, has a change of heart before the redemption period, that's not a crime, right? You're saying this crime doesn't actually kick in until the redemption period runs?
I would have to be able to prove a felonious intent. I'm not sure how I could do that.
If they sold it immediately, that would be.
Perhaps. Yes, but I mean, there are cases where, the defendant goes and gets legal counsel, and the lawyer says, yeah, you have the right to these things. That's a defense. So, I mean, I can't say it's a black and white matter, but when you have somebody who, when they're asked, where did you get this stuff, he says, Craigslist. Oh, no, it didn't come from this house. I'm pretty sure I can prove felonious intent at that point, when it was severed, when it was removed from the premises, and at the end of the redemption period.
So is the lesson to be learned from this case that when you know you're going to lose your house, gut it before the sheriff's sale?
Well, yes, because the legislature has provided now that you can go in and inspect before the sheriff's sale. So yes, if you gut it, I mean, yes, you are infringing on the mortgage holder's rights.
Well, they inspected on Tuesday, the sheriff's sale's on Thursday, and on Wednesday, the house is gutted. Now what?
Right, so there is a question whether you would be committing larceny against the mortgage holder, and that kind of depends on whether the mortgage is simply a security for the repayment of the note, or whether that's an actual interest in the property.
Doesn't the buyer at the sheriff's sale get something more than the mortgage holder has?
Yes, absolutely. This is what I'm saying, is now the legislature has said that the purchaser, whoever wants to purchase this house, has the right to inspect it. And so they should know what they're getting.
Could it be that the legislature needs to address this issue? Maybe that's what this is instead of a larceny? Something that needs to be, a gap that needs to be filled by the legislature?
Well, I mean, if you steal something from somebody else, that's a crime. I mean,
But if you steal it from yourself, it's not. And that's our problem. We're saying we stole it from both. And we're focusing a lot on stealing it from the other person, but you still have the problem of also stealing it from yourself.
Why are you so steadfastly ignoring the civil remedy? The civil remedy is designed to make the foreclosure purchaser whole in the event that the possessor and occupier abuses the property in some way.
well, because in many, many cases, that civil remedy is going to be useless. If the fixtures aren't recovered, then it's highly unlikely that that person is going to be...
There is a larceny sanction. Even Blackstone, who defined it very narrowly, understood that if the fixture were removed and taken in one single sequence, that might not be violative of a larceny, but to do something in 2 or 3 episodes might well implicate a larceny.
I thought you were saying that the civil remedy would substitute for the criminal.
Well, I'm just saying you've ignored the civil remedy. That's worth something. It may not be the magic remedy that provides everything that the foreclosure purchaser may wish, but it's not insignificant.
It's not insignificant, but I would say in the majority of cases, it will provide no relief and no...
I don't understand why
But
you
of
say
course,
that.
what's the homeowner going to get back? If we're worrying about, putting money back in the hands of the purchaser at the sheriff's sale, criminal liability isn't going to put money back in their hands either.
No, it's not, but it's going to stop this conduct from happening in the
Just
first
deterrent.
place. It's a deterrent, exactly.
I understand that. I just thought we were focusing on making the guy whole.
Well, thank you very much.
Thank you, Your Honor.
Case is submitted, and we are adjourned until tomorrow.